India Legal presents Courts Roundup.
Hello, I'm Hisha and you're watching Courts Roundup. In this program, we bring you the latest legal news and details of court proceedings. And before we begin, here's the headlines. In Amaravati land case, Supreme Court issues notice on the appeal by Andhra Government challenging stay granted by Andhra High Court on SIT probe. Supreme Court reserves judgment in challenge to Central Vista redevelopment. Court rejects argument that no new structure can be constructed in Central Vista area. Supreme Court issues notice in a fresh petition seeking a stay on Uttarakhand High Court judgment ordering a CBI probe against Chief Minister Trivender Singh Rawat. The Madras High Court directs Tamil Nadu Government to reclaim land belonging to temples by removing all encroachments.
India Legal presents Courts Roundup.
A three-judge bench of the Supreme Court headed by Justice Ashok Bhushan issued a notice to Telugu Desam Party leader Varla Ramaiah on an appeal by Andhra Pradesh government against Andhra Pradesh High Court order stalling probe into Amaravati land scam. The Supreme Court has issued notice on the appeal by Andhra Pradesh government challenging stay granted by Andhra Pradesh High Court of the SIT probe into alleged irregularities into projects started by the previous TDP government, including land acquisition in Amaravati. A bench of Justices Ashok Bhushan, M.R. Shah and Subhash Reddy also issued notice on the plea seeking revival of the SIT probe and posted the matter after 4 weeks for final disposal. Senior advocate Dushyant Dev appeared for the YS Jagan Reddy government and submitted that the High Court order is extraordinary. He said that it stopped the entire investigation into allegations of fraudulent practices and abuse of power. Further, Dev added that the High Court could not have exercised such broad powers as it is also bound by the laws declared by the Supreme Court. Justice Bhushan-led bench issued notice on the appeal as well as on petitions for interim relief. Respondents have been directed to also file counter affidavit and liberty has been granted to file additional documents. Andhra Pradesh government has moved the Supreme Court against High Court order restraining any media reporting as to the FIR registered by the Anti-Corruption Bureau, alleging corruption and illegal land transaction in relation to the shift of the capital to Amaravati following the bifurcation of the erstwhile state of Andhra Pradesh in 2014. The Andhra Pradesh High Court, while staying the SIT probe, had noted that rule of law demands continuity and a new government cannot be permitted to overturn the decision of the previous government. The High Court had further held that government in exercise of its executive powers does not have an inherent power of review. However, the plea before the top court contended that investigation in this case could not be termed as a power of review. Bureau Report. The Supreme Court has reserved its verdict in a batch of petitions challenging the redevelopment of New Delhi's Central Vista area, which houses historically significant buildings and structures including Parliament House, Rashtrapati Bhavan and India Gate. The court during the hearing made it clear that it is rejecting the argument no new structure can be constructed in Central Vista area. The matter was heard by a three-judge bench of Justices A.M. Khanwilkar, Dinesh Maheshwari and Sanjeev Khanna, which granted time to the parties till November 16 to file their written arguments. The centre Wednesday told the Supreme Court that there was no arbitrariness or favoritism in the selection of the consultant for the proposed Central Vista development project comprising of a new Parliament and Central Secretariat buildings. The division bench of the Delhi High Court had on 28th of February stayed an order of its single-judge bench which had asked the DDA to approach the court before notifying any change in the master plan for going forth with the centre's ambitious project to redevelop the Central Vista. The High Court stay order on the single-judge bench February 11 direction had come on the intra-court appeal of the DDA and the centre. The petitioner before the High Court had opposed the Central Vista project on the ground that it involves a change in land use of the green area adjoining Rajpath and Vijay Chowk for building new parliament and government offices. And the Supreme Court has sought response from centre in plea against practice of affixing posters outside COVID-19 patient home, and the plea also challenges the practice of forwarding of names of COVID-19 patients by State Health Department to Resident Welfare Association as being unlawful.
The Supreme Court has asked the central government to reply to a plea questioning the need to affix posters outside the homes of persons affected by COVID-19. The bench of Justices Ashok Bhushan, R. Subhash Reddy and M.R. Shah has sought a reply within 2 weeks. The court initially awaited the presence of Solicitor General Tushar Mehta, who was busy with the Central Vista hearing. It then gave time to the union to reply with a short affidavit in 2 weeks. The centre informed the court that the plea has been forwarded to the concerned department. During the hearing, Justice Bhushan observed, "We cannot issue directions to each state. One circular should be followed by all." Justice Shah also observed that the court cannot issue orders in every such case. The petition filed through advocate on record Puneet Taneja has challenged the decision taken by state government under the National Disaster Management Act 2005 to affix posters outside the homes of COVID-19 patients who are in isolation. The plea also challenges the practice of forwarding of names of COVID-19 patients by state health departments to Resident Welfare Association as being unlawful. It is stated that the circulation of such names on WhatsApp groups, etc., is a violation of fundamental rights of privacy and the right to live with dignity as enshrined under Article 21 of the Constitution. The petitioner had filed a similar plea in Delhi High Court, in reply to which the Delhi government on October 8 had taken a decision to stop the practice of pasting such posters. The petitioners averse that patients who are undergoing mental trauma and weakness due to COVID-19 have also been subjected to stigmatization by the members of neighborhood and community due to such a practice. The court has thus asked to pass directions to all states who are still affixing posters outside the homes of COVID-19 positive patients to stop such practice forthwith and take down all existing posters. It also seeks direction to all states to stop the circulation of the names of patients on WhatsApp groups and among RWAs. Bureau Report.
And the Tamil Nadu government has denied BJP permission to conduct a Vetrivel Yatra. The government cited COVID-19 as a reason for the decision, and the BJP was to conduct the Vetrivel Yatra celebrating Lord Murugan to consolidate Hindu votes ahead of the Tamil Nadu election next year. The Yatra was to begin on November 6th and end a month later.
The Tamil Nadu government has told the Madras High Court it would not allow the BJP to conduct the Vetrivel Yatra, which was held in the state between November 6 and December 6. The government cited COVID-19 as the reason for its decision. The state is expected to officially communicate its decision to the state BJP unit later in the day. It was assumed that the BJP was to conduct the Vetrivel Yatra celebrating Lord Muruga to consolidate Hindu votes ahead of the Tamil Nadu elections next year. The yatra was to begin from Tirutani on November 6 and end at Trivender a month later. Modelled on Rath Yatras, the campaign was to cover the 6 major temples of Lord Muruga in the state. Taking a cue from controversy where a derogatory video on Kandha Shasti Kavasam, a devotional song on Lord Muruga, was uploaded by a YouTube channel, the BJP announced a month-long Vetrivel Yatra. Initially, the party had also planned to conduct public meetings in the above 6 places with the campaign kick-starting in October. But with the police refusing permission for the public meetings, citing COVID-19 pandemic, BJP was forced to drop the plan. The High Court was hearing 2 petitions which sought a ban on the yatra due to COVID-19. The petitioners said it would pose a threat to the public and create law and order problems. They also claimed the yatra was scheduled to end on December 6th, the anniversary of the Babri Masjid demolition, only to create communal problems. Chief Justice Amreshwar Pratap Sahi and Justice Senthil Kumar Rammurthy disposed the petitions and allowed the state BJP unit to challenge the government's order. In court, state BJP President L. Murugan argued that the central government guidelines no longer prohibit religious congregations and only insisted on ensuring social distancing. Several political parties are opposing the yatra, alleging it's a strategy for riot politics. Now with the 2021 Tamil Nadu Assembly elections due in a couple of months, the BJP is desperate to change the current trend. Even when the majority of country has been swayed by Modi wave, Tamil Nadu has been standing strong with anti-Modi wave. On multiple occasions the last couple of years, the state has made #Go Back Modi trend on social media. This time around, the Saffron Party, with many such new and popular faces, is trying to break into the state. Bureau Report.
And the Supreme Court has issued notice in a fresh petition seeking a stay on the October 27 Uttarakhand High Court judgment ordering a Central Bureau of Investigation probe against Chief Minister Trivender Singh Rawat. The order passed by Justice Ravindra Maithani of the High Court had also quashed the FIR filed against investigative journalist Umesh Kumar Sharma. On the last date of hearing, the court had granted a stay on the part of the order calling for the CBI probe against the Chief Minister. Appearing for the state today, senior advocate Mukul Rohatgi argued that the order needed to be stayed in its entirety. However, the court observed that it cannot revive a quashed FIR unless the order is set aside. The matter will now be heard after 4 weeks. In a video released in June this year, Sharma had alleged that an amount of 25 lakh rupees was paid as bribe to Chief Minister T.S. Rawat by one Amaravati Singh Chauhan for his appointment as chairman of the Gau Seva Ayog Jharkhand. Rawat was the BJP state in charge of Jharkhand at the time, and the amount was alleged to have been deposited into various bank accounts, including those of Dr. Harinder Singh Rawat and his wife Savita Rawat. In this June 2020 video, Sharma asserted that Savita Rawat was Trivender Singh's sister, making Dr. Harinder Singh Rawat his brother-in-law. The FIR listed various offences against Umesh Sharma for making corruption allegation tying Dr. H.S. Rawat and Savita Rawat to Chief Minister T.S. Rawat. In his video, Sharma was accused of cheating, forgery, conspiracy and allied offences. Finding that none of these offences are prima facie made out against Sharma, the High Court quashed this FIR. The Madras High Court has directed the HR and CE Department to initiate appropriate action to retrieve land belonging to temples by removing all encroachment. Justice R. Mahadevan also directed that the land belonging to the subject temples shall not be alienated or leased or encumbered illegally and against the interest of such temples and shall only be used for temple-related purposes. The court also criticized the HRCE department, which is the custodian of the temple properties, for having not taken any steps to protect the interest of the temple. Such callous attitude on their part cannot be countenanced. The court was considering a batch of writ petition challenging the transfer of land belonging to various temples to other departments entirely, partially, and also encroachment. Certain government orders which order transfer of the disputed land to the Fisheries Department were challenged. The court held that the temple are entitled to the rights of possession and enjoyment in respect of the respective disputed land subject to the control and administration of the HR and CE department, and no trustee private individuals shall claim right over the disputed land possessed and enjoyed by the temples in any manner whatsoever. The court also added that the government shall not utilize, alienate, assign, transfer the same and construct permanent structures therein for the purposes other than the beneficial interest of the temple. We are now joined by Advocate Shivam for more updates.
Yes, in this case, the court observed that temples in Tamil Nadu are not only a source of identification of the Asian culture, but also a testimony of pride and knowledge of the talent in the fields of art, science and sculpture. The court directed the Hindu Religion and Charitable Endowment Department to identify and safeguard all temple lands from encroachers with an officer in charge filing periodical reports. The court also said that HRCE department shall take all steps to construction by putting a compound wall to secure and safety of the land. Except for temple-related purpose, the land should not be used for any other purpose. Proper register with respect to the financial aspects of the subject temple and its properties, and file the same before the authority concerned at regular intervals. Yes.
Thank you, Shivam, for the update. Moving on, the Punjab and Haryana High Court recently bumped up the cost imposed on a litigant to 1 lakh rupees after his lawyer said that he had made many judges and paying cost was not an issue. Whereas the court had initially dismissed the plea with cost of 50,000 rupees, the lawyer had jocularly expressed eagerness to pay even sum of 1 lakh rupees if necessary. While it took exception to the lawyer's boisterous claim of having made many judges, the bench expressed that it would exercise self-restraint. The lawyer's objectionable remarks followed his client's petition being dismissed by the court. He controversially claimed that his submission could not be dismissed by the bench since he had made many a judge. Justice Monga observed in his order that the lawyer's conduct left a lot to be desired. The bench was hearing a petition moved for the registration of an FIR against certain private respondents for fraud. The petitioner claimed that even though a complaint was made by him, no action was initiated. There was an additional prayer for direction to dissolve an educational charitable trust of which some of the private respondents were trustees. The petitioner asserted that he had invested 1.25 crore rupees in the construction of the trustees' building, and dismissing the case, Justice Monga opined that the cases seem to essentially be civil in nature and that criminal complaints were sought to be instituted only to settle private scores. Noting concealment of facts on the part of the petitioner, a cost of 50,000 rupees was imposed on him to be deposited in the state's COVID-19 relief fund, and this sum was enhanced after the petitioner's counsel objectionable statement. And the Bombay High Court has directed the Secretary of Union Ministry of Information and Broadcasting to conduct an inquiry into the disclosure of personal data of over 4,000 right to information applicants on its website. The order was passed in a plea filed by activist Saket Gokhale, seeking the removal of his personal data from the ministry website. The bench of Justices Nitin Jamdar and Milind Jadhav directed the ministry to complete the probe and submit a report within 3 months, failing which liberty was granted to Gokhale to approach the High Court. The court also directed the Union of India to pay 25,000 rupees towards litigation cost incurred by Gokhale, and the court further granted liberty to Gokhale to move the civil court for damages incurred due to such disclosure of his personal details. Last week, the court had reserved its verdict after both parties concluded their submission. Gokhale submitted that the MIB's action was in violation of precedents set by the Supreme Court. He informed the High Court that his details were visible on the website as recently as the first week of September this year, when the court raised a query to the MIB to clarify whether details of all RTI applicants were uploaded on their website. The ministry replied that Gokhale was not singled out and that details of over 4,000 RTI applicants had been uploaded by the CPIO. And the National Green Tribunal has expanded the ambit of hearing cases on pollution due to firecrackers and issued notices to 18 states including Assam, Meghalaya and Nagaland where air quality is beyond norms. A bench headed by NGT chairperson Justice Adarsh Kumar Goyal has sought responses from Assam, Meghalaya and Nagaland. The NGT was hearing various pleas seeking action against pollution by use of firecrackers when the air quality is unsatisfactory with the potential of the severity of COVID-19 pandemic. Earlier, the NGT had issued notices to Delhi, Haryana and Uttar Pradesh, and the states of Odisha and Rajasthan have already banned the sale and use of firecrackers. The tribunal said it may have to consider prohibiting the use of firecrackers to protect the health of people in 122 non-attainment cities where air quality, as per record maintained by the CPCB, is generally beyond permissible limits. However, the NGT did not specify the names of the cities in Assam, Meghalaya and Nagaland where the air quality is beyond the permissible limits. The NGT notice was served to the Chief Secretaries of Assam, Meghalaya and Nagaland, sources said, and have been asked to respond by Thursday. The NGT on November 2nd had issued notice to the Ministry of Environment and Forest and some state governments on whether the use of firecrackers be banned from November 7 to 30th in the interest of public health and environment. And that's it for Courts Roundup. Thank you for tuning in.
India Legal presents Courts Roundup.